probably.
Okay, does anybody listen to me? Lori Anderson versus Armani Lyman. Bueno. On that side. State your names, please.
You're gonna be over.
State your name. All right. I reviewed everything in the file and
All right, pause for a second. What we're watching here is basically a landlord-tenant dispute, and the judge is already trying to push both sides toward a settlement conference. That's actually pretty common. Courts prefer when parties resolve things themselves instead of dragging the case through months of hearings. But judging by the tone already, this conversation might not stay calm for very long.
just to try to resolve the matter if we can. Set it for a final settlement conference today to see if there's a resolution. Ms. Lyman,
Yes.
do you still wish to reside in the property?
Yes, last court date, she asked me to stay and I decided that I was.
Pardon?
Last court date, she talked to me after the court asked me to stay, so I decided that I will stay.
Okay. And Ms. Anderson, where are you on this case?
I want to apologize for talking.
Pardon?
I want to apologize to you for over talking.
It happens. All right.
I just hesitate because I'm worried about the condition of the property. From the outside, there's already damage, and Ms. Lyman has approximately $20,000 of damage on a prior property on Maplehurst. Mr. Fink told me about. So, I mean, I have a $500,000 property now.
Now things start getting interesting. The landlord just mentioned $20,000 in damages at a previous property. That's a pretty serious allegation. But here's the legal catch. Unless there's actual evidence or a claim filed about that damage, the judge can't really rely on it. Courts deal with proof, not rumors. Still, hearing something like that immediately raises the stakes in a dispute about property.
Worried about it coming down with Ms. Lyman, since she has a prior history of damaging property.
Go ahead, Ursula.
Honestly, I feel like the little Fink situation on June 27th, he had contacted her.
I don't know what that means.
So I feel like that's a conflict of interest, and we're here for 42 for not Maplehurst. So I don't see why that's being brought up, and for that was a small situation.
Hold on a second. I don't know anything about that. So that's not under my head. Let me ask you this. Has rent been paid and everything, or?
No, I have not.
All right.
She said she would put the $3,300 in escrow.
All right. Is that what you would do, ma'am?
Yes, I did say that, but our last court date, you said that $25 a day was excessive. I ended up paying that $25 a day last month, so I was asking if I could pay
$25 a day?
Yes, so I was asking, could I pay $3,000?
Well, there's gonna have to be a claim on that, but what's the monthly rent?
$3,000.
All right. So I won't give a discount on that. We'll figure it out, but you've agreed to put that into escrow? The 3,300? Put it to place $3,300.
This is where the judge tries to simplify the chaos. The key issue isn't late fees, arguments, or past drama. It's rent and escrow. When rent is placed in escrow, it basically means the money is held safely until the court decides who should get it. Think of it like a financial pause button while the legal fight plays out. It's one of the court's favorite tools in landlord-tenant cases because it protects both sides.
In escrow, and that's really for the month of July, correct? And then 3,300 per month thereafter. All right. Folks, just in terms of resolving, go ahead.
What I was about to say, because last month I ended up paying the $25 a day, so I ended up paying.
I hear you. You're about to repeat yourself. I will resolve that once we get to the end of everything.
Oh.
If it is indeed illegal, but I'll figure it out. Yes, ma'am.
Last time you said that I could get $100 for late fees for.
I'm not gonna deal with late fees, folks. All right now. I'm just not. I mean, the issue is that if there's gonna be an agreement that she'll stay, because you filed the termination case, we have to figure out what the terms of that will be. Yes,
I really don't want her to stay because I'm worried about damages to the property.
okay, so didn't we just go through this? You guys had a conversation about her stay, right? There then becomes this issue regarding damages at other place. I don't know anything about that. You're worried about damages at the premises. So what I was going to suggest to the parties is this. Would you object, because actually I can order it in any event, but that she's permitted to do an inspection of the premises.
There's no damages to the property.
Okay. Yes.
There are, from the outside, there are already 3 damages. There's oil stains in the driveway. There's blinds and the blinds in the back have been damaged. The screen in the back has been damaged. So that's just what I can see on the outside damages. And that's probably.
And there it is, the moment you can hear the judge's patience starting to crack. Does anybody listen to me? That's usually the signal that the conversation has officially gone off the rails. Instead of arguing back and forth about stains, blinds, and screens, the judge proposes the most logical solution: an inspection of the property. In court, inspections are powerful because they replace arguments with actual evidence.
Okay, does anybody listen to me? Because it would seem to me that the way to resolve this issue would be for you to be permitted to do an inspection of the premises. Yes.
Also, she would need to change the locks back because I didn't authorize her to change the locks.
What does that have to do with anything right now? Yeah.
I don't want to offend you.
What?
I'm trying not to offend you, so I don't want to.
I'm not easily offended, so go ahead.
I just, if she wanted to work something out, I would have to be able to talk to her and not the older woman. I mean, there has to be some communication between me and her and not me and this older woman. And she would have to abide by the terms of the lease. That's all I'm asking, sir. I would work things out.
Yes.
She keeps talking about an older woman when.
Okay, so first of all, stop, both of you. I don't know. We come so close and then you guys just start talking past each other about stuff that may in the end not mean a thing. So the first thing is, if her tenancy is going to be maintained, you got to get the 3,300 into escrow.
Now the judge lays down the roadmap. First, the tenant has to put $3,300 in escrow. Second, the landlord gets an inspection of the property. And third, both sides come back to court later so the judge can review the findings. This is classic courtroom damage control. Take the emotional fight, turn it into a structured process, and let facts do the talking.
You want to do an inspection of the premises. What date are you going to do the inspection? What date would you like to do the inspection?
This week.
All right, would you be available to let her in to do the inspection this week?
No, I have school and work for the rest of the week. Mandatory. Could we try for like next week?
Monday, next week. What's wrong with that day?
What time?
In the afternoon, Monday would work. I was just asking a question.
What's the question?
Did you, ask her to change the locks back?
No, she's gonna be there. I'm not gonna deal with that right now. Okay? What I'm gonna do is there's gonna be an inspection on the premises.
So you do that.
So there'll be an inspection on the premises on the 21st. 2025 at, will 2 p.m. work for you? Yes? 2 p.m. All right. Then I need you guys back on, I'm gonna move this to, when's my hotspots block on the first?
3 p.m. Your Honor.
So then I want to see you guys August 1st, 2025 at 3 p.m. That'll be an in-person hearing. Back, we'll look at what the inspection is and how we can go forth with this tenancy.
And notice the landlord's concern at the end. How do I pay the mortgage if the rent is in escrow? That's actually a very real problem landlords face in these disputes. But legally speaking, escrow isn't about convenience. It's about neutrality. The court holds the money until it decides who deserves it.
If the rent is in escrow, how do I pay the mortgage with the rent in escrow?
Well, it's going to be an escrow. I'm not clear, ma'am. It's going to be placed in escrow at this point in time, and then we'll figure out what we do on the first. Okay? Anything else from either side? I'm almost afraid to ask.
Just can I be able to call her on her phone and talk to her?
I don't know. Are you capable?
Yes, I.
Okay. Will that work for you?
Yes.
And you'll answer? Okay. That's resolved. Anything else? Great. We'll see you on the first. Thanks, folks.